I'm Karen Singleton. I'm the Policy President for the Animal Justice Party, and I'm joined by Danette Weerita, who is the co-leader for AJP. So I want to be upfront. Neither of us are lawyers. We've approached this submission as lay people with expertise in animal welfare, protection and justice. We also want to note that only 10 days were given for this submission, with oral submissions called the very next day of it closing. That's an extremely tight time frame for a bill this significant, and we don't think it really gave the public enough time to respond properly. So the Animal Justice Party opposes this bill, and we call for it to be withdrawn. What stands out to us most is how broad the bill's protection is. It doesn't just shield one type of emitter. It protects virtually anybody responsible for emissions, including government departments, ministers of the Crown, foreign-owned companies, and operating here. In substance, this bill protects polluters at the expense of everyday New Zealanders who are left with no way to seek compensation or hold anyone accountable for climate-related harm. Now, we've heard today a lot of submitters talk about certainty, but there's no real certainty to be had in a world facing climate crisis. What this bill offers might be certainty for a small group for a limited time, but it's not certainty for the country. From a justice perspective, what we do understand is this: what counts as harm worth taking seriously isn't a fixed notion. It's decided by government through regulation and legislation, and those decisions aren't made in a vacuum. The people and industries with the most resources and influence often have the greatest ability to shape where those lines get drawn, sometimes in ways that keep their own activities out of reach of any meaningful accountability. This bill seems a clear example of that in action. It decides a whole category of harm caused by emissions, will never again be tested in court, no matter how serious or how clearly linked to a specific source. That's not a small or minor choice. It's a decision about whose harm gets taken seriously and whose doesn't. So courts exist precisely because law doesn't always keep pace with harm. They're one of the few places where that gap can be tested. This bill closes that door, not just for future cases, but for ones already underway, like Smith versus Fonterra, a case that's been going through the courts for a few years now. We've also seen it argued that courts aren't equipped to deal with something as complex as climate change, but our own Supreme Court has already rejected that idea when it allowed the Smith versus Fonterra case to go ahead. It pointed out that courts have adapted before to industrial pollution, water contamination, multiple polluters causing shared harm. It didn't see climate change as fundamentally different, just bigger in scale. So we don't see why that reasoning should change now. And I'll hand over to Danette if you're there.
Kia ora. It's also worth remembering that a lot of serious harm happens through completely normal, everyday, even legal business practice. And many of today's business models have been built around harmful environmental practices into how they operate as standard, not as an exception. That doesn't make the harm any less real, and it doesn't make the consequences any less foreseeable. This bill looks to us like an attempt to run away from accountability for that harm, rather than face it. Now, we care about this because animals, wild and farmed, don't get a vote. They don't get a say in Parliament. Climate change is already reshaping their lives, warming seas, changing rainfall, shrinking habitat, and it compounds other pressures that they're under too. The courts are one of the only places where harm to them and to the environment they depend on can still be raised, even when politics moves too slowly to act. Removing that option doesn't make the harm go away. It just makes sure that no one can be held accountable for it. We'd also ask the committee to think about who this bill actually protects. It's not about communities facing flooding or drought. It's not about the insurers left holding more risk. It's about the industry and companies whose emissions are the reason we're having this conversation at all. Shielding the parties most responsible while leaving everyone else to carry the cost doesn't strike me as a reasonable use of Parliament's time. So in closing, the question isn't whether Mike Smith will ultimately win, it's whether he should be allowed to have his case heard. If the defendants believe they've done nothing wrong, why not let the case be heard? Why not let the evidence be tested? Justice should be allowed to take its course. Now, listening to Fonterra's submission today, it struck me that they were simply arguing their defence, but this committee isn't a court. If Fonterra believes that evidence is on their side, they should let justice take its course and present that evidence at trial. And is the possibility of economic impact enough to stop a court case? This assumes very blindly that the economic cost of environmental harm doesn't matter, when in reality it could be far greater. We ask the committee to think about your legacy with this decision. Do you want to be remembered for preventing a court from tearing evidence or for allowing justice to take its course? Today it's climate change, tomorrow it could be something else, and it's a very dangerous precedent to set. We'd ask the committee to think about what happens to the harm that falls outside today's law. If this bill passes, there's simply nowhere left for them to go. Given the short time that the public has had to respond, we also ask the committee to consider whether more time and more scrutiny is warranted before a change like this is made. We ask you to reject this bill. Kia ora.